I'm James Turner. I'm a barrister at Quadrant Chambers, and I'm going to talk to you about negotiating damages. What are they? When are they awarded? And how do you evidence them? Now, damages are supposed to put the injured party where they would be if the duty hadn't been breached. They're not always easy to quantify, but generally it's a workable system. So what's with negotiating damages? Negotiating damages, also known as Rutham Park damages, after the case by that name. Negotiating damages are quantified by imagining a negotiation between reasonable parties in the position of the actual parties, a negotiation over a release fee or a license fee to permit the breach, conducted hypothetically just before the breach. Now, when are they awarded? It's actually easier to say when they are not awarded. They're not awarded when conventional damages are available. But sometimes conventional damages don't work. Now, the classic case, it's a slightly Victorian example, but the classic case is imagine you have a horse and you keep the horse at a stable on terms that nobody but you is allowed to ride the horse, and somebody else rides your horse. And the horse is uninjured, probably the better for the exercise, but have you suffered no loss? You've obviously suffered no financial loss. Have you suffered no loss that the courts will award to you? And the answer is that the court will award you some damages for that. It'll award what are known as common law user damages, because in essence somebody has taken something for nothing, and the court won't put up with that. And the something would be probably the going rate for taking your horse out for a ride. Now, at common law, negotiating damages are available and available only for infringement of a property right or an analogous interest in an asset. So rights over land, trespass and so on, intellectual property rights, patents and things of that sort, and duties of confidentiality. They are not available for breaches of what one might call a bare contractual right, such as a non-compete obligation or an undertaking not to trade a ship, which I'll come back to. Now, a contractual right may give rise to one of these analogous to property rights, such as a duty of confidentiality, but a contractual right for these purposes is not on its own an asset. The final point to bear in mind for common law negotiating damages is that, as with all damages at common law, they are retrospective only. You can only have damages for past breaches, past damage. Now, things get more interesting when you move on to equity. Historically, you could get no damages at all from a court of equity. So if a court of equity established that you had suffered a breach which gave rise to damages, you then had to go back to the common law court in order to be awarded your damages. The courts of equity could only award injunctions and orders of that sort, perhaps setting aside a transaction for undue influence, something of that nature. So this was procedurally very inconvenient. And in 1858, Lord Cairns had Parliament pass Lord Cairns Act, which is now to be found in Section 50 of the Senior Courts Act. And it allowed the courts of equity to award damages either instead of an injunction or as well as an injunction. Now, this has the advantage that it can apply to prospective breaches, to damages going into the future. But it's worth bearing in mind that it doesn't just apply to negotiating damages. Damages of all sorts can be awarded under Lord Cairns Act. But there are some limitations. So the first is that they can only be awarded at all, damages can only be awarded at all, if the court still has jurisdiction to grant an injunction. If it doesn't, then there's no jurisdiction under Lord Cairns Act to award damages. Damages are only available instead of an injunction if the grant of the injunction would be oppressive. And that's quite an important limitation. There's no question of people simply being able to buy an entitlement to infringe somebody else's rights because that's what suits them. Thank you very much. And in those cases, the court will grant an injunction and put a stop to it. And the third limitation is that damages for past breaches are awarded on the same basis as the common law, and so you won't see any particular difference there. Now, to give some examples, I mentioned Ruton Park at the beginning of this talk. Ruton Park was a case where, in breach of a restrictive covenant over land, somebody built a housing estate on it. Nobody sought an interim injunction, but they applied for an injunction to have the whole housing estate torn down, and no doubt the fields reploughed at the end of the trial. But by that time, not only was the housing estate there, but people were living in it. And unsurprisingly, the court said, well, no, it's much too late for that, it would be oppressive, but we will award instead negotiating damages based upon, in that case, a percentage of the profit that the developer had made breaching the covenant by building the housing estate. Another example is a case involving Jimi Hendrix's back catalogue, or rather the part of his back catalogue that he never wanted to see the light of day. And there was an undertaking given never to exploit that part of his back catalogue. That undertaking was breached, and again, impossible to show financial loss, but negotiating damages were awarded as a sort of retrospective license fee for the infringement that had taken place. Ships built to a confidential design, but in breach of a contractual duty of confidentiality. That sounds a bit strange. A shipyard was licensed to build 4 ships according to a particular design, and that was it. And it built the 4 ships, and then it built another 24 for other people. Again, not possible to show any actual direct financial loss, and damages were awarded on the basis of user damages at common law. You won't find that in the case reports. That was a case in arbitration. A case that is in the law reports, a contractual obligation not to trade a vessel that was sold for scrap. The vessel was traded, and 3 fixtures were entered into. Now, nominal damages only were available for the past breaches because no financial loss could be shown, and the court granted an injunction on the facts of that case to restrain the performance of the 3rd fixture, which hadn't started. But the court made clear that if instead of it not having yet started, actually it was on the cargo carrying leg of the voyage, then quite possibly negotiating damages might have been awarded in that case. Evidence. Now, what sort of evidence do you need to prove and establish something which, of course, never in fact happened? Because you're trying to evidence a hypothetical negotiation. Well, you go about proving it in just the same way as you do any case. You call factual witness evidence. To take the case of the shipyard that built the ships it shouldn't have done, it was necessary to show what else the shipyard would have been doing if it hadn't been building those ships, because that would have had an impact on the negotiation which would have taken place. So how big were its facilities, what was the market like at the time, what other ships was it building, and so on. And so you build up a picture of the business considerations and pressures that would have been operating on the actual parties at the time, even though, in the hypothetical negotiation, you imagine reasonable people who want to reach a deal actually conducting the negotiation itself. And of course you can have expert evidence too, expert evidence on market practice for the licensing of ship design, say, and possibly forensic accountancy if there are some difficult numbers involved. So, drawing the threads together, in practice, negotiating damages are neither as rare as hen's teeth, nor are they as common as muck. In the right circumstances, they are a valuable means of stopping a party getting away with taking something for nothing. If you want some further reading on this, I recommend 2 cases, the Supreme Court decision in the case of One Step and the subsequent commercial court decision in the case of Priyanka Shipping. And that is everything you need to know about negotiating damages in 10 minutes.